Good afternoon. This is Kim McCleary, President and CEO of the CFIS Association, and I'm glad to see so many people have joined us this afternoon for the 12th in our 2010 webinar series. Today our topic is the nuts and bolts of disability insurance, and as many people wrote in the registration process, although we've had a number of different speakers talking about medical topics and research topics, for some individuals this is the most interesting topic to them because it's an issue and a challenge that they're facing right now in their personal lives that they know they could benefit from the expert advice. And we're delighted to have Charles McBrayer, Mac Sasser, with us this afternoon to impart his many years of wisdom and experience on the disability process. So I see that we've got a lot of people still joining in. Sorry that we were a minute or two late in getting started, but we will spare no time and get right underway. Before I introduce Mac, we have just a few housekeeping details. The group that registered for today's webinar is a little bit different from the one that we've had for the past 3 or 4 sessions, in that about half of the folks who registered today, this is their first webinar. So we'll take a little bit of time just to orient everybody to the technology and to the way the program will unfold. As I mentioned, this is our 12th webinar. We've covered a variety of topics, but this is the first on a legal issue that is quite common challenge among people who have CFS and related disorders. For those of you who haven't taken part in a webinar before, as you can tell by now, we can't see you, you can't see us, and Mac and I cannot see each other. Although we're both here in Charlotte today, we're in different locations, each in our own offices, and we don't have the benefit of nonverbal communication to send each other signals about timing or how to do various things to switch controls, so bear with us if we have to have a little chatter about that. As of just a little while ago, we had about 210 people pre-registered to participate today, and we know that many more are planning to watch this recording once it's posted on our YouTube channel, which will happen within the next day or two. There were a lot of questions submitted with registration, and I've kind of compiled those, and that's how we'll get started with the Q&A session that follows Mac's presentation. But if you think of a question that you'd like him to address, please type it into the little field that you'll see on the right-hand side of your screen on your dashboard for the webinar. And those questions actually will all come into me, but we'll have just a dialogue after the formal presentation and hopefully cover many of those as we can. As I mentioned, the recording is hopefully taking as we're moving through, and we'll post that online in a couple of days' time. We do issue a follow-up email that gives you all the URLs you'll need to find the slides and the recording. And just as a reminder, although Mac is a practicing attorney and is very experienced in disability case law, he's not able to address individuals' questions about their specific cases or claims. This format just really doesn't work well for that, and we're trying to keep this information general. So please try not to submit questions about specific pieces of evidence or actions that you and your insurer or employer may be involved in right now. Just a couple of things about what we learned about this particular audience during the registration process. First of all, in our 12 webinars, I don't think we've ever gotten so many questions submitted in advance on such a wide range of issues and questions. So we have our work cut out for us today, and Mac knew that already. He said to me yesterday he could spend an entire day on any one of the dot points that he has outlined in a few brief slides, because this is such a big topic. As I mentioned earlier, about half the audience is participating in their first webinar today, so we have some people pioneering this technology, and we welcome you today. 77% of the registrants indicated that they were most attracted by the topic. It's usually a little bit more spread out between the topic, the speaker, and just the chance to learn something new from home. So this is a very focused audience on this particular subject matter. And about half are in the process of applying for benefits, and that would be for any of the different kinds of disability benefits that Mac will describe. And 30% have a pending claim, and I've just kind of broken those out by the 3 different categories that we'll cover today. So that gives both Mac and the rest of the participants some idea about who else may be participating with you today. And now it's my pleasure to introduce our speaker today, Charles Mac McBrayer-Sasser, who is an attorney here in Charlotte. He has his own practice, the Sasser Law Office, that has specialized in a number of personal injury issues, including disability law, and has represented many, many claimants with CFS, fibromyalgia, and related disorders over the years. Mac has also held various leadership positions in the National Organization of Social Security Claimants Representatives, the long version of the professional organization called NOSCR, which is a little different from NASCAR, which is also based here in Charlotte. But through that organization, Mac is in touch with many, many other attorneys and people working in this area, and that's a great organization to keep in touch with if you're going through that process. They have a lot of resources for claimants as well as their representatives. And I just also wanted to add that Mac served on our board of directors for many years, and so we got to do a little catching up yesterday because it's been too long since we've spoken on the phone. But Mac is very familiar with this organization and certainly with the community, and keeps well up to date on medical and research topics that often touch on the disability topics as well. So Mac, if I've forgotten anything, I'm sure you will fill us in, and I'm delighted to turn the presentation tools over to you so that you can lead us through this important discussion.
Thanks very much, Kim. Kim, just a quick tip to me. Do I hit the Show My Screen button now?
Yes,
as we go forward? Okay.
Yep.
So that gives me the control to switch back. I can quickly get my mug off the screen so people don't have to look at that too much longer.
And he's really not that intimidating looking a character, although I bet for his the people he represents, he's happy for them to look that way in a hearing or an ALJ session. So, all right, it's all yours.
Well, thank you very much, Kim. I appreciate that generous introduction. And the topic that we are going to try to go over today is a remarkably comprehensive one. And as Kim alluded to a few minutes ago, there really isn't going to be a way for us to explore these topics in an exhaustive fashion or a very detailed fashion. So my goal today and my hope is that I'm going to be able to share some experience and share some overviews of these topics that will assist people in being more comfortable with the concepts that one often must explore and must understand when one is trying to put a disability claim through any one of these 3 systems. What we'd like to do today is try to cover 3 different topics because there are many different types of disability legal systems in the United States. We're going to explore 3 of them. We are not going to explore state-run disability systems or local-run disability systems where benefits or other amenities can be afforded to folks with disabilities. We're not going to explore any type of disability discrimination statutes or remedies today, but instead we're going to focus on the types of disability legal matters that bring money into folks who are disabled into their homes and households because of their disability. The 3 primary topics that we're going to go over today are private disability insurance policies, number 2, employer-provided disability insurance policies, and number 3, the Social Security disability system. So with that in mind, let's turn to the first topic if we can. Private disability insurance is an industry in the United States that is run primarily through insurance companies. Many insurance companies for years and years have had policies in place that an individual consumer can go into the marketplace and shop for and purchase that insures an individual against the loss of income if that individual experiences a disabling impairment that meets the disability definition in the policy of insurance. So this claim, in essence, is really a contract claim. The individual who purchases the insurance policy from the company is, in a sense, entering into a contractual relationship with the insurance company. They pay the insurance company money or a premium that's usually done on a monthly or an annual basis. And in exchange for that, the insurance company, just like fire insurance for your home or car insurance for your automobile, provides a policy that says if this event occurs in your life, we are going to pay you a defined benefit. That benefit is normally a function of your salary or your wages, and the premium that you pay and the type of coverage that you buy will dictate the amount of the premium that is involved in the claim. The amount of income that you're insuring, the greater it is, the greater your premium is going to be that you pay to the insurance carrier. The issues that we deal with in the legal profession with respect to these policies are the issues that arise when people have purchased a policy and for a host of reasons the insurance company, or carrier as we call them, does not pay, or there is payment and then that payment stops or terminates. So the nature of the claim that a person walks into my office or into a lawyer's office who does this work presents to us is really a breach of contract claim. The disability insurance has decided not to pay the disability benefit that the person has tried to insure themselves to receive by paying those premiums over the years. What happens when a disability insurance company welches on its obligation? Well, in many cases, the disability insurance company is positively reinforced for denying or terminating a case because the people whose benefits have been denied or terminated don't do anything about it, or they attempt to rectify the situation on their own and write a letter or try to get their doctor to make another statement. And in that process, there is often a failure to understand that it is a legal issue that's being decided, which is based on, in large part, on medical facts, but it's really not so much a medical determination. It seems like it should be. From a logical standpoint, it would seem that the medicine and your doctor's opinion should dictate what the insurance company does. But in fact, the doctor and the medical records provide a platform on which legal analysis is superimposed and legal decisions are made with legal consequences. And so with that setting, what we attempt to do when a person comes into our office with a disability claim with a private carrier is we try to explain the nature of the claim, just as I've just explained it here, and then we go through the process of how we can do something about what's happened. The first thing that has to happen is the policy will set forth steps and guidelines that the policy holder has to follow in order to perfect or prosecute their claim. And those steps or those steps that are set out in the policy have to be followed in an exact way and in a way that adheres to the exact procedure that's set out in the policy. It's very, very important to set the claim up to give it your best chance of succeeding, to follow those guidelines and steps in the policy. what we do first is, of course, we review all of the medical records and all of the policy materials, and we also have to look at all the correspondence that's come, because that's going to give us a clue to the insurance company's position. Often, even after those steps are followed, we call them administrative steps, but after those administrative steps are followed, there gets to be a point in time where the insurance company that has the policy simply issues a final decision and says, no, we're not going to pay this claim, or yes, our decision to terminate this claim is going to be upheld. When that occurs, then the claimant or the policyholder has a certain period of time in which to file a lawsuit. The lawsuit is filed against the insurance company, and it, again, as I mentioned earlier, is in the nature of a breach of contract claim. There are a number of different statutes of limitations that apply. It depends on the state where the claim is brought. It can depend on the state where the policy was written, or the state whose laws the policy is subject to. But your attorney who focuses in this type of case will understand these issues and will file the lawsuit that needs to be filed within a certain statute of limitations period. When that occurs, normally these cases end up in federal court. As many of you probably know, there are two different court systems in the United States. One system is a state court system, and then the second system is the federal court system. Often, since the insurance claimant lives and is a resident of a state different than the state that the insurance company has its headquarters in, these cases end up in federal court because citizens of different states with certain amounts of money at issue have the right to have their claims heard in federal court as opposed to having their claims heard in state court. In any event, the court system process is a long one, and these cases, depending upon the jurisdiction that the case is filed in, will often go on for years. The lawsuit is filed by writing what's called a complaint, and that's filed, and then after a period, an answer is filed by the insurance company, and then after the initial documents, those pleadings are filed, the parties will engage in what's called the discovery process. That means that the parties will have the opportunity to ask each other written questions and also to have depositions of witnesses. The claimant's deposition will almost always be taken. The depositions of various doctors or insurance company personnel may be taken, depending upon the type of claims that are filed by your lawyer who's filing the suit. After a long period of discovery is over and documents are obtained and the answers to the questions that your lawyer will ask are explored and answered, the case will eventually come to trial. And that trial happens normally in front of a jury, although the parties can elect to have it in front of a judge if they choose, but most plaintiffs will choose a jury. And it's very, very similar to the process that many of you are familiar with by watching television shows or the movies, although, of course, trials never happen like you see in the movies or like you see on television. They do occur with witnesses being sworn, evidence being taken, testimony being given in open court, and the jury reaching a decision. Once that decision comes down, either side can appeal the jury's verdict to a court of appeals if it's in state court, to the state court of appeals or appellate division of the state court system. Or if it's in federal court, it will go to a circuit court of appeals. When the appeals are exhausted, the case will be finalized. The final decision in the case could be that you've won and that decision is upheld on appeal. It could be that if you've won at trial, the decision is reversed on appeal. Or it can be, if you've won at trial, the decision might be remanded for a new trial to take additional evidence or to correct some error that the trial court made. So as you can see in this explanation, this process in the court system is a long one and an exhausting one. And it's one that you really have to have a lot of fortitude to persevere through. The remedies that you can obtain in a private disability insurance case are the remedies that you can obtain in a contract action. First, you can obtain the benefits that the company did not pay you. Second, you can obtain interest on those unpaid benefits if you win your case. In some jurisdictions and in some types of cases, you can obtain attorney's fees. In some jurisdictions and with some types of cases, punitive damages may or may not be appropriate. But the lawyer that's representing you in this type of action will have his practice focused in this and will understand what types of remedies are available to you, but those are some examples. The thing to expect in prosecuting a private disability insurance claim varies depending upon how large the claim is. If your benefit amount is in the nature of $10,000 or $8,000 a month or more, you're going to have a very difficult, you'll have a very stiff defense. The insurance company will put up a very good defense. They'll hire good counsel, and you'll be battling these cases for a long period of time. During the process, I failed to mention a minute ago, during the process there is one moment in that process when when cases like this that are in court can resolve, and that is in most federal court systems and state court systems now, there are mandatory mediation or alternative dispute resolution stages in the litigation where the parties are required to appear with a neutral, an arbitrator or mediator, who then will try to settle the case by getting the parties to come together and find some common ground. In any event, in that mediation process, a neutral, usually a retired judge or another lawyer, will be appointed or chosen by either be appointed by the court or chosen by the parties, and will listen to the arguments of your lawyer and the lawyer of the insurance company, and then will try to effectuate some type of resolution or settlement. Mediations are not always successful, but sometimes they do result in a resolution of the claim at that time, and thus obviating the rest of the process that I described a few minutes ago. Timetables, I think we talked about those. Let's go forward and talk about the next major topic that we're going to try to explore today, and that is employer-provided disability insurance. Employer-provided disability insurance is by far and away the more common type of private disability insurance in the United States. Many large and medium-sized employers have as a part of their benefits packages disability policies for their workers and employees. Those benefit policies, just like retirement benefits or health benefits or vacation or other types of employer-provided benefits, are controlled or regulated by a federal statute called the Employee Retirement Income Security Act of 1974. The acronym for that is on your screen, ERISA, and we call that an ERISA case. ERISA disability claims function in a very different way than the breach of contract private disability insurance claims that we discussed a few minutes ago. These types of claims are claims that are highly regulated, and there is a very limited window for the presentation of evidence in these claims. these claims are, in a sense, even trickier and more problematic than the claims that we talked about a few minutes ago with private policies. The reason for that is because so much of what has to happen in an ERISA insurance disability case happens before there ever is a case in court. In essence, in an ERISA case, the trial of the case, the trial that we discussed you would have in a private policy case a few minutes ago in court in front of a jury, that trial happens not in a courtroom, not in front of a judge, not in front of a jury, but instead it happens in front of the very insurance company that wrote the policy under which you're trying to claim a disability benefit. That insurance company is charged in the ERISA statute and regulations with deciding any disability claim that's presented to it within a certain period of time, and then giving the claimant the right of appeal to that same insurance company's bureaucracy to try to get that decision overturned if it's unfavorable. Those appeals end up in a final determination. And in many jurisdictions, not all, but in many jurisdictions in the United States, that final determination by the insurance company on the appeal marks the end of the time when evidence can be produced by the claimant or entered into the record of the case. Because of that door shutting, so to speak, on the production of evidence, when a final decision is made, the practical impact of that is immense for the claimant. It means that all of the evidentiary work that goes into proving a case that normally occurs during the court process that we talked about a few minutes ago with the other type of disability claim, all of that really must happen during the stages of the game, so to speak, that occur in front of the insurance company itself. So in ERISA disability cases, your attorney will use a completely different strategy and a completely different approach in prosecuting that claim. And it's very important in those claims to get into the offices of the disability or ERISA practitioner as soon as possible and not to wait until there is a final decision. In many situations when folks come into our offices, they've tried to prosecute those claims themselves on their own, and with great internet research and high IQs and wonderful education levels, those claims still are not going to be able to be prosecuted successfully unless one understands case law precedent and the regulations and statute that ERISA superimposes on how these claims are decided. And so we are very encouraging of people to try to find counsel as early in that process as they can. The ERISA claim is initiated by the employee when they become sick or disabled, simply filling out a form or an application notifying their HR department or the insurance company directly that they're going to file a claim, and then completing the form that the insurance company or provides to the HR department or to the employee. When that claim is filed, the insurance company, as I said, will have a period, it's a regulatorily prescribed period of time to make a decision in the claim, and immediately what needs to start happening is evidence needs to be marshaled and collected and presented. And all kinds of evidence needs to be collected, not just a person's medical records. Vocational issues need to be explored, work experience issues, job requirements, all kinds of what we call collateral witness statements need to be taken. all of these things go into the record that is in front of the insurance company. It's the insurance company's claims file. Sometimes the insurance company may call it its administrative record in these ERISA cases. But during the time that this evidence is collected, the insurance company is supposed to be considering these pieces of evidence as they come in. Though often that doesn't occur, it's still incumbent upon them ultimately to look at this. And their decision is supposed to be reflective of the evidence that's in their claims file that's been submitted. Eventually, when the claimant goes through one or two appeal stages in front of the insurance company, a final decision will be rendered by the insurance company, and then the person will have a statutorily prescribed period of time to file a lawsuit if they're dissatisfied with that final decision. The statutes of limitations for the filing of ERISA claims also vary from state to state and jurisdiction to jurisdiction, and that's a question that your lawyer should be able to answer simply by understanding where the claim is going to be brought. Let's see. When you go to your attorney with an ERISA-based claim, often these applications will be filed by the employee themselves, and they will get a denial or they'll receive benefits for a period of time and then get terminated. When that occurs and they go to see an attorney because they're dissatisfied with the termination or the denial, what the attorney will want to see is every single thing that the employee has ever collected about any benefit plan or program that their employer provides, not just the disability plan or program. And that's because in many of these cases, other employee benefits, such as contributions to retirement plans or health insurance continuation or the like, may depend on the proof of disability under the long-term disability plan that the employer has provided. So in other words, if a person is disabled from working and goes out and proves their disability with the disability insurance company through the employer's plan, that person may be entitled to continuing health insurance benefits. That person might be entitled to continuing contributions to their retirement plan or continuing life insurance coverage. Those types of issues are very important for your attorney to look at and explore because since they can be dependent upon the LTD or long-term disability determination, that person's family needs to know the answers about those issues affecting those other benefits. In any event, the timetables in an ERISA case are, as I said a moment ago, the timetable for appealing is going to be in your plan or in your policy. The regulations prescribe various periods of time. Usually after the first decision, there is going to be a 180-day or 6-month time to make that appeal. And I would caution everyone listening today that 6 months, though it may seem like a long time, is a very short period for your attorney to get their work done in an ERISA disability case, because during that period of time, all of the evidence from those sources that I described a few minutes ago has to be collected and evaluated. And as that evidence comes in and your attorney sees holes or gaps or questions that needs to be answered, you have to go back to those sources and get additional records or additional evidence so that those holes and gaps can be plugged, because by the time that final decision is made, your attorney is going to want to make sure that everything possible that can support that decision for you is in the insurance company's claims file. So very important, because once that final decision is issued in many jurisdictions in the United States, that is the end of the period, as I mentioned earlier, when evidence can ever be submitted in that claim. So if that final decision is a negative one and your denial has been upheld or your termination has been upheld, in those circumstances you really have no other option other than to file a lawsuit against the plan the employee benefit plan and the insurance carrier, or your employer if it's a self-insured plan. And when that happens, the court in those jurisdictions where the record is closed at that point, the court is going to only be able to look at what was in that claims file or that administrative record as of the date of the insurance company's final decision in the case. In other words, when you file your lawsuit, unlike virtually any other case that you can file in our country, you will not have a trial, you will not have a jury, you will not testify in open court under oath, you will not have an opportunity to, even if years go by during the process, you will not have an opportunity to update your records if there is a change in your medical condition or if your condition gets worse. You will not have an opportunity to have your doctor heard in open court with his or her sworn testimony. You are stuck with whatever is in that record in many jurisdictions. There are some exceptions to that, but in many of the jurisdictions in which we practice, that's the rule. And so everyone really needs to be, no matter where you live, needs to be thinking about your ERISA disability case in this way so that you do not waste the opportunity to have what in effect is your trial, which happens before that insurance company's final decision is ever remedied or ever entered. So once that final decision is made and a lawsuit is filed, as I said a minute ago, the judge must decide your case based upon what is already in the record. And if there is evidence in the record which can support or could support the insurance company's decision, the standard of review in ERISA cases can be very harsh. It can be what's called an abuse of discretion standard. And when there is an abuse of discretion standard review by the federal court in your ERISA claim, you need to make sure, you need to have made sure that in your file, in that claims file, by the time of the final decision of the insurance company, every single scrap and piece of evidence that you can possibly marshal is in that record, because that's the only thing that the judge can look at. And because the standard review is harsh and is very strict in many ERISA cases, it just behooves you and gives you more power in the litigation when your record is very strong. Oftentimes in these claims, the insurance company will have sent you to their own doctor. We call those defense medical examinations, or DMEs. The insurance company likes to call them independent medical examinations, or IMEs. But in truth, there are very few of those examinations that are independent. In fact, the carriers seem to gravitate towards hiring doctors whose opinions they can count on and whose opinions they have a pretty good idea of how they're going to come down. And those DME opinions have to be rebutted and met by your attorneys, but it has to be done in the administrative process in front of that insurance company. It's too late to do that if you filed your lawsuit in federal court. You just don't have that opportunity in an ERISA case. The other issue in ERISA cases, which makes these cases difficult and which makes finding counsel difficult often, is that the remedies in the ERISA claim are much restricted. Unlike the breach of contract case that we talked about a few minutes ago, the ERISA remedies that a claimant can win are really quite limited. Essentially, the disabled individual can only win the benefits that the insurance company owed them in the first place. The court can award interest on back benefits that are unpaid, but the interest rates are not necessarily wonderful, and that's not really a negative for an insurance company to face that. And in some cases, courts will award attorney's fees. The court has the discretion to award attorney's fees in an ERISA case to a prevailing party, but it doesn't have to. And it's certainly true that in a number of cases where plaintiffs prevail, that is, the disabled worker or employee actually prevails, attorney's fees will not be awarded, leaving the remedy in the case really just the benefits that the carrier should have paid in the first place and some interest. This is not a very big disincentive for an insurance company, and it positively rewards the carriers, along with those standard of review issues that I mentioned a few moments ago. It positively rewards the carriers to make bad determinations and to deny or terminate cases just to see what will happen. In these cases, like the contract cases we talked about earlier, we see many, many folks with these cases simply throwing up their hands after the first denial and not doing anything about it or waiting too late to do something about it. And that, of course, rewards the insurance company, and it becomes a numbers game for them. If they deny or terminate 1,000 claims, how many of those 1,000 individuals will actually appeal or find their way to my door or an attorney's door that does the kind of work that we do? And the answer is certainly not 100%, probably not 75%. It's probably closer to 50%. And those numbers reward insurance companies for this bad behavior. And because the remedies in ERISA cases are so restricted, there's no way of really disincentivizing the carrier for that behavior. The overall nature of ERISA is very anti-consumer and anti-policyholder, and is very pro-insurance company and pro-big business. An attorney who understands and knows ERISA can be a tremendous asset to you, but the overarching message that I would try to communicate about ERISA cases today is that every single person listening to this webinar needs to be writing their congressperson and their senators about modifying and reviewing and overhauling the ERISA statute, because the statute is what it is, and until it changes, the behavior and the process that we're going to see in these ERISA claims is really not going to change. Those of you who have employee, or rather employer-provided disability insurance policies and are going through this process probably already know what I'm talking about. But these cases are crying. We see horrific fact patterns in these cases, highly unjust results, and the only way that this is going to be rectified in a systemic manner is for there to be an overhaul of the statute. And I just would encourage people to become involved politically and to try to do what they can in their states with their congresspersons and their senators to effectuate that type of overhaul. Let's turn, if we can, with our remaining time. I know we're getting short on time, aren't we, Kim?
You're doing fine. I think people will hang in there as long as
okay.
You stay with us. So.
Well, as I mentioned to Kim yesterday, each one of these topics and each of the subtopics that we've talked about can really be the subject of a multi-hour or day-long seminar for lawyers, and so it's real difficult to describe these with the broad brushes that we're using this morning. But let's try to go through Social Security disability cases for a few minutes, the third topic that we're going to try to cover. A Social Security disability case is divided. There are two types of disability benefits that are available through the Social Security Administration. By far and away, the most well-known one and the most common one is the disability insurance benefit. Every time an employee or worker pays a Social Security tax, they are in essence paying an insurance premium. And that system was set up in the 30s, or actually not in the 30s, that was the retirement system, but it was set up in the mid-20th century to insure folks who became disabled before reaching retirement age. It is an insurance system that is one of the principal features of the Social Security system that we have in place today. And that system pays a defined benefit that's calculated using the number of quarters that a person has worked in their lifetime and their earnings over their lifetime, which are factored into an algebraic equation, and a benefit is determined. That benefit is paid when a person proves disability under the Social Security Act and its regulations, and that disability begins prior to age 65. That disability benefit will pay them their full, what's called primary insurance amount benefit, unless they have dependents, and then the benefits are apportioned among dependents as well as the disabled person. But in any event, that benefit is paid up through their age 65 and then, or 66, depending upon their retirement age under the system. And then at that point in time, the disability benefit stops and their retirement benefit begins. But the important thing to understand in the first instance about the Social Security system is that it is, by and large, an insurance-based system. It is not a welfare benefit. There is a welfare disability benefit available through Social Security, but it's an entirely different system, and it's even though the rules are the same for determining disability, the benefit is quite different, and it's not based on wages, it's based on need. A person in the welfare side of the system has to prove not only disability, but also must prove need, financial hardship and need that is set out in the regulations. We will not go over those type of benefits in our presentation today. There's just not time. Instead, we're going to focus on the insurance side of the system. If one becomes disabled and one has the requisite number of quarters of earnings in the Social Security system, one can apply for disability benefits at any time. It's a common fiction or commonly held notion that is a fiction that you must wait for 12 months before applying for benefits. That's a point of confusion because the disability definition under the Social Security system says that one must be disabled for 12 consecutive months in order to receive a benefit. That's true, but in order to prove disability, you need only show that you have been disabled for 12 consecutive months, or, importantly, that you will be disabled for 12 consecutive months. So my advice for folks who become disabled from working is that you apply even though you have not yet reached that 12-month mark, assuming, of course, that your doctors and you both believe that you will be disabled from working for 12 consecutive months. The reason that it's so important to get that claim moving is because the Social Security system is a very long system. In our jurisdiction here in North Carolina, just in the place where Kim and I live, getting a hearing in a Social Security case often will take 2 years. This is a tremendous hardship for people who are disabled without wages or earnings, and so, as you can imagine, it behooves this person to start that process early. The Social Security disability system is a 4-tiered administrative stage system. An initial application must be made. It can be done over the telephone or online or at your Social Security office. When that decision or when that application is made, you will get a decision from Social Security, normally within 6 to 12 weeks or so you will get a decision. It will almost always be a denial. Certainly cases involving PWCs, in my experience, are most often a denial. I think the statistics presently for initial application denials are that over 60 or 65% of people who apply for Social Security disability are denied on that initial decision. When the initial decision is received, the claimant has 65 days from the date on that decision to appeal, and appeal they must. It's very important not to drop the case at that point or to refile a new claim, but instead it's important to actually make the appeal, and it's simple to do. You simply write a note and file it with the Social Security Administration that you wish to appeal, and they'll ask you to fill out some more forms, and you'll do that. And you're requesting in that appeal a reconsideration of the initial decision. And after those papers are filed, the Social Security Administration will issue its second decision in the case. So you will have gone through 2 of the 4 tiers at this point, and you will get a reconsideration decision. About 90% of people who ask for reconsideration are denied again. When that reconsideration denial is received, it's very important that the person appeal for the second time to the 3rd stage of the administrative process. You'll have 65 days to make the appeal. You've put your appeal papers filed, and you are at this stage requesting a hearing. This 3rd stage of the administrative process of the Social Security system is the most important stage for you, because this is the stage where your lawyer will have an opportunity to appear in person in front of a judge in an administrative hearing that's held in an Office of Hearings and Appeals, which is an arm of the Social Security Administration, in a city, your city or a city near you. And in that hearing, your attorney will be able to examine and cross-examine witnesses and present evidence on your behalf and make an argument to the judge, who's actually looking at you and listening to you as you provide sworn testimony in your hearing, and who's actually looking and listening to the other witnesses in your hearing as well. Because of that more formal process and that hearing, the nature of the hearing process, this is the point in the administrative system of the Social Security system where you have the best opportunity to win your case. Experienced practitioners who are capable Social Security disability attorneys will often win 85% of their cases. And so this is a very important stage to seek counsel if you haven't done so already. Normally it's better to get counsel involved earlier, but if you haven't done that before the hearing stage, certainly by the hearing stage you want to have experienced counsel involved. If you lose at the hearing stage, your lawyer will have 65 days from the date of that decision to make a 3rd appeal in the administrative process and go to the 4th stage of this process, the 4th and final stage, which is called the Appeals Council. And the Appeals Council stage, a reviewing body looks at the administrative law judge or hearing judge's decision and decides whether to affirm it or to reverse it or to remand it for another hearing. When that Appeals Council decision is issued, that is the final decision from the Social Security Administration, and 65 days from that decision, your attorney has the right to file a lawsuit in federal court against the Social Security Administration if you and your attorney believe that that's warranted. Then your case goes through the court system, the regular court system. But as you can imagine from listening to the explanation, this process is a long process. Unlike the ERISA disability process, though, it's a process where evidence can be submitted all the way through the administrative process, and you really do have, and there's some, and in federal court as well, you can submit new evidence if certain conditions are met. But because of the length of the process, there is a much greater opportunity for submitting evidence and for having that evidence considered than in the ERISA process. The remedies or the benefits that you can receive, we went over those for a moment when we were talking about the nature of the claim to begin with, but briefly to summarize those benefits, it's just a wage algorithm that is based on your quarters of coverage and the amount of money you've earned in your lifetime and contributed to the system. And those benefits you're eligible to receive as of the 6th month after the beginning date of your disability. And you can receive back benefits as far back as a year prior to your application for disability. And so often, because of the length of time that's involved in the Social Security disability process, the back benefits can be significant. And then you're entitled to an ongoing monthly benefit through your retirement age or through that time that you become not disabled. Kim, I think we're about out of time, and I'll wrap up, so perhaps there'll be a chance for me to answer some questions.
That'd be great, Max. Okay, so you're wrapped up now, or did you have some final conclusionary wisdom to share with us?
Well, I think that if I had to summarize, I would just emphasize that all three of the disability systems that we've discussed this morning have their own set of rules, have their own laws, their own procedure, their own guidelines. They are separate and distinct from each other. They can influence each other. What happens in the Social Security disability case, though it's not dispositive, it isn't enough to ensure that you're going to win your ERISA disability case or your private insurance contract disability case. It can be very helpful. Certainly the evidence that's germane to one case can be germane to the other. But in summary, these systems are quite distinct and different. Different rules apply, different in many cases, different procedures apply, different courts decide these cases in the first instance. And it's just important to keep that in mind as you try to explore your particular alternatives in any of these systems. Because you are filing a Social Security disability case, it doesn't mean that the things that you've done in the Social Security disability system are going to necessarily apply or work in the ERISA disability system. You'll commonly see courts comment on the fact that the disability definition is different or that the standards of disability are different for these systems. So it's really important to understand that each system has its own set of rules and procedures, and you need to approach them in that way. Other summaries, Kim, I guess I could go on for another hour really and summarize again, but I feel like I'd be repeating myself. There's so many different aspects of these claims that we have not touched on today, and I'd like to give people an opportunity to ask me some questions and maybe bring out some more information if they've got time. I realize we're a little bit over right now.
Yeah, so we've got, if you've got a few minutes, we've gotten a lot of questions.
Certainly.
Registration process, and then a lot more have come in while you've been talking, some of which are rather specific and relate to topics kind of outside these three types of insurance claims. So we won't, unfortunately, be able to get to things like supplemental insurance and other types of employee benefits. But I know in having the benefit of hearing you talk about this over many years, one of the things that has always struck me is how each of these systems is really set up to try to allow whoever's paying the benefit to sort of outwit and outlast the person who's seeking the benefit, whether it's Social Security or an employer-based program or private benefits. And that one thing I have tried to encourage people to do is not to give up, because that's what they're counting on. Would you agree with that general advice?
I would wholeheartedly agree with that. I've been doing this work now for 25 plus years, I guess, and I would wholeheartedly agree that particularly with the ERISA system and with the Social Security disability system, those systems are, whether they were set up intentionally to accomplish this, I'm not going to comment. But the practical effect of the way those systems have been set up is to weed out folks who are quitters, to weed out folks who cannot last and who don't have the perseverance to prosecute a claim. And so it's unfortunate because folks who have become disabled from working are among the most vulnerable folks in our community, and they're the very people that need assistance or consideration quickly, and instead they get the opposite.
So in building any of the claims that you've shared with us today, what in your experience has been some of the best types of evidence for individuals to try to build into their case, the types of testing that won't necessarily be definitive, but that can have kind of an added cumulative effect in terms of proving the disability?
Well, the very best evidence in these cases, of course, is a sound medical record where you have a treating physician who is seeing you on a regular basis, who, though they may or may not be prescribing medications for you, is at least examining you in a clinical fashion on a regular basis and adds credibility to what ultimately is a subjective claim of fatigue or cognitive issues or what have you. Any type of testing that can help to define or measure exertional levels, bicycle ergometry testing, for example, can be helpful in the disability process. We've seen, tilt table testing helpful. We're going to see other tests that come up that are helpful. None of these tests are dispositive. Having a positive bike ergometry test is not going to win your disability case. But as you alluded to, Kim, each of these pieces of evidence has sort of a cumulative effect, almost a psychological effect on the fact finder, because as these pieces of evidence accrete, the fact finder is more and more impressed with the amount of effort that's going into diagnostics, the amount of effort that's going into treatment, and it just automatically gives credibility to this type of claim. Credibility is the most important factor in any disability claim. The claimant's personal integrity and credibility is the most important factor, because especially in CFS cases or fibromyalgia cases where the very diagnosis is often controversial and is often based, as insurance policies will sometimes define and specify, it's often based on subjectively reported symptoms, symptoms such as fatigue, symptoms such as cognitive deficits. These subjectively reported symptoms turn entirely on the credibility of the reporter, of the person experiencing those symptoms. And so I find that that credibility issues often are of paramount importance in these claims. How does one enhance your credibility? The first thing, of course, is utter truthfulness and candor in every aspect of your life and in every aspect of your interaction with medical professionals and vocational experts. It just has to be the order of the day. And then the other thing too is your advocate has to have great credibility. Your advocate has to have that same degree of integrity and credibility to present your case in a way that is going to influence and sway the fact finder. So I think we've probably gotten a little far afield of your question, but there isn't any one particular piece of evidence that's the be-all, end-all to proving a disability case. It is an accumulation of pieces of evidence, and it's not just medical. I know I've been talking about medical tests, but there's so many aspects of a successful disability claim that are not medical. There are the statements about the observations of your family members or your friends about what they see and what they hear with their own senses when they are around you. Those statements can be remarkably important. The statements of your former employers about your attitude, about your performance, the statements of vocational experts that your attorneys will employ about your skill set and about the characteristics of your former work or of other jobs that may exist in the economy in your area. Each of these things have their role and have their part in putting together a successful disability claim.
And so along those lines, Mac, when you're sent by either your disability insurance company or the Social Security Administration for some type of follow-up medical exam, whether it's a defense medical exam or a CME, to see a practitioner who is not your own physician of record, do you have any guidance or advice for people on how to prepare for that and what to expect and whether they should bring any documentation with them to that visit?
That's a great question. In the Social Security system, what happens in that system is that Social Security will often in the early stages, the initial or reconsideration stages, will send you to consultative examiners, or CEs as we call them. In my experience, those examinations are rarely helpful. They are done in most situations because the administration has the power to do them. They have a budget for doing them. They use those CEs to bring a medical opinion into the record that's not the opinion of a treating physician. Sometimes they can be helpful if there really isn't a lot of treating physician history in the file. But by and large, I find those not to be helpful. They are, however, in most cases, in our experience, harmless. We don't see many administrative law judge decisions at that third critical stage, the hearing stage, turning on just the CE examiner's opinion. Treating physician evidence is always going to, or is supposed to, under the law, be given greater weight than consultative examiner opinions, and so we just don't see the CE opinions being that huge a factor in the ultimate decision in the Social Security process. Now, by contrast, in the ERISA disability system or in the private insurance contract disability system, defense medical exams that are set up by the insurance company can be very, very important, and they can be make or break exams sometimes, depending upon how the exam goes and what your attorneys do in reaction to that examination. I don't want to sidestep the question, Kim, but in the litigation context with the private insurance company disability policies or the employer-provided disability policies, the claimant really needs to consult with their experienced counsel about what to do in each of those situations. In some cases, not all cases, but in some, we may ask our client to go to the examination with records of past medical treatment or films or other lab reports or what have you. In some cases, we may ask them to go in with a witness, a family member, or we may go in and ask them to take a tape recorder and tape record the examination. In some cases, you may go even so far as to have a court reporter attend the examination with the defense medical examiner and literally take down through stenography everything that is said in the examination and be able then himself or herself to testify about what occurred. The range of responses to defense medical examinations in the ERISA context or in the private insurance contract context are highly fact-specific, and there's just no blanket answer, but they're very important milestones in those processes, and they need seriously.
If you'll indulge me, just two more quick questions about Social Security related issues.
Sure.
That have been asked a number of times. The first is what the coverage is for individuals who become disabled when they are young, as students, or for stay-home parents who don't have the work history years that you had mentioned, I think 6 quarters, or if somebody has been in the workplace but worked part-time impact.
I don't think I actually did specify a certain number of quarters because the quarters of coverage requirement changes depending upon your age. Younger people can obtain Social Security disability insurance benefits without the same number of quarters of coverage that older workers need in order to show insurability or to show coverage. So if a worker is in their 20s and they don't have the quarters of coverage that an older worker would have to have, there's still a possibility they can obtain benefits. I don't want to say a specific number today because I'm just afraid of giving advice that people might rely on to their detriment. It would be better to consult with your Social Security disability attorney, give them your age, all of your work, including work in high school jobs and the like, even part-time jobs during school or college are important. Sometimes the earnings in those jobs do not get presented to Social Security, and it's just very important to go over those with your individual attorney.
Okay. And is there a statute of limitations on Social Security? In other words, do you have to apply within a certain period of time from the point of becoming disabled without putting
Yeah, that's a good question, and I don't. And the answer is yes. There is an horizon or a sunset on the application process. It's a long horizon. I'm drawing a blank on what that is right now. It rarely comes into play. If you apply for disability within 2 years or less of your having become disabled, you're certainly going to be able to prosecute your application. Most folks don't apply for disability until more than a year has passed after they become disabled, and those applications are safe. There is a sunset, though, and what I'd like to do, Kim, if I may, is get back to you and post that or email that to you and put it up on your YouTube or your webinar presentation page so that we get that exactly right. I don't want to misquote.
Right. Thank you. And gosh, there are so many questions.
I'm happy to stay around for another 10 minutes if you want. I'm happy to do that.
Very generous, and I think for the most part our audience is hanging with us.
Okay.
Let's see. Let's keep this particular question to the Social Security, but maybe you'll, within that context specifically, if your doctor has made more than one diagnosis, many people carry, for instance, a dual diagnosis between chronic fatigue syndrome and fibromyalgia or irritable bowel syndrome, which is the best diagnosis to use, or should you use all of them?
Good question. The answer is consult with your lawyer, number one. Number two, our experience would be that we normally use the strongest claim as the primary, or the strongest opinion as the primary piece of evidence, but we certainly don't exclude alternative diagnoses, fibromyalgia and CFS. We often see people who have both of those diagnoses. We don't do anything to disguise or exclude one of those. We submit all the evidence that mentions one, either, both of them. We may focus in our arguments or our presentation more on one than the other, but that's going to be a decision that's made, during the litigation process as you're presenting your case for trial, or in the Social Security system, or for trial in the private disability system or ERISA disability system. We do not exclude diagnoses, though, and my view is generally you present everything that you have, and you don't try to pick and choose diagnoses.
And I'm at least aware of people who go in with one diagnosis and their claim is paid based on something else that's seen in the record.
Correct. You'll often have a case where in the Social Security system, for example, you'll have a case where the judge that's deciding your case is just not convinced about the evidence of chronic fatigue. Maybe he's a skeptic about the condition. Maybe he just doesn't think that the medical evidence is there to support it. But you'll find you can still win a favorable decision by looking at some other type of malady or condition, an anxiety-related issue, for example, or a cognitive issue, for example. So better to keep all those tools in your toolbox.
Right.
Yeah.
A lot of people have asked about getting help from an attorney and at what point in the process they should engage legal representation. From what I've heard you say, the earlier the better.
That's a general blanket rule, and there are really very few exceptions to that. In the Social Security system, I think it's relatively safe to apply for the disability, and you may be one of the 30% of the folks who win, and you will not have needed an attorney. And I don't think that there's not a lot of downside to that. But certainly, if you receive a denial, you need to get an attorney involved in your claim then to just begin the process of marshaling the evidence you need. You're not going to be able to look at your own medical records and know whether those are enough unless you do Social Security disability work, or you do ERISA disability work, or you are a lawyer doing private contract disability cases. You're simply not going to understand what the words in that medical record mean to the lawyer or judge that's the fact finder and decision maker in your case. And it's very important to get someone who's really focused and experienced in these kinds of cases involved early. But in the Social Security system, I think if you get them involved at reconsideration and before hearing, you'll be fine. But in the other two systems, particularly the ERISA system, that one is just key, really key to having that representation and that insight and that experience involved in your claim very early.
And with regard to Social Security, the Social Security Act actually provides for the compensation that legal representation is able to earn through representing you. Isn't that correct? It's capped.
Yes, there are regulations and guidelines. Fees in the Social Security context have to be approved by the Social Security Administration. The normal fee in those cases for counsel is 25% of the back benefits that are won for the claimant, up to a threshold or a ceiling. And that ceiling, it's $5,300 or something thereabouts. Actually, I think it's just gone up to a little over $6,000. but $6,000, but whichever is less, the ceiling or 25% of the back benefits, that's the fee. And if you enter into a fee contract that specifies that fee and that conforms with the Social Security guidelines, that fee contract will be approved by the Social Security Administration, and they will subtract that amount of money from your back benefits and pay that directly to your counsel. In the other cases, the ERISA cases and the private contract disability cases, fees are not regulated by any agency or administration. In those cases, those fees are simply a matter of contract between you and your counsel. Often those cases are done on a contingency fee basis, which means that your lawyer will not charge a fee unless your lawyer wins money for you. And then your lawyer is entitled to receive a fee on any and all benefits that are won for you through that lawyer's representation and efforts. And if you enter into that type of contract, I would just encourage you to read the contract carefully and discuss it, any questions that you have with your attorney, and get those questions decided up front. It's very, very important to understand those things. But fees in the other two types of cases are normally contingent fees, and they're just contractual. So it's a matter between you and your counsel.
Last questions, and then we will let everybody get on with their afternoon. And thank you for being so generous with your time.
Certainly.
This question comes up. It's come up today, and it's come up many times before about the use by private disability insurance companies and employer-provided plans of surveillance of benefits and claimants, and using videotape.
Snoops. We call them snoops down south. Yeah.
Episodes of dog walking or grocery store trips against the claimant in the process.
What would you like me to address about that?
If you could just comment on that generally, and how you guide people in dealing with that kind of invasion.
The larger the benefit amount at stake in the claim, the greater the likelihood the insurance company, whether it's an employer-provided insurance benefit or whether it's a private insurance contract benefit, the larger the benefit that the disabled worker or individual is entitled to receive under the policy, the more likely it is the insurance carrier is going to invest, $1,000 or $2,000 or $3,000 or even more in hiring a snoop, a private investigator, to follow that person surreptitiously or attempt to watch them secretly and understand what that person does on a day-to-day basis. We've had stories where my clients have gone out to get the newspaper in the morning, and guys with cameras have fallen out of bushes. We've had folks who have seen strange white vans sitting at the end of their, half-mile-long driveway out in the country with telephoto lenses, and you just hear all kinds of stories like that. And they're hoping to catch you doing something on tape that is going to prejudice your claim, even if it's really not something that, when you think about it, should be dispositive of whether you're disabled or not. It's nonetheless going to be done, because if that investigator sits in front of your house or down the street for 6 days, 5 hours a day, and only comes away from that experience with 10 minutes of videotape, but those 10 minutes are of you mowing your grass or, playing football in the yard with your kids, or, or taking 50-pound sacks of fertilizer, dragging them across your yard or whatever, that is going to have a tremendous psychological impact on the fact finder. Even though it might only be 6 or 10 minutes out of 30 hours of time, and the rest of the time the tapes doesn't show anything. It's just blank. You're in your house, or you tried to mow the grass, and then you're in bed for 3 days afterwards. Of course, it's not going to show you in bed for 3 days afterwards. It's just going to show you for the 20 minutes you're mowing your grass. But those kinds of tapes are dangerous because they are used to influence the fact finder, and it's not so much in a logical way as it is in a psychological way. They're also used to influence your doctor's view. Oftentimes these tapes will find their way from the insurance carrier into the hands of your treating physicians, and they attempt to discredit you with your treating physician and to get your treating physician to have a little less faith in what you tell them when you come in complaining about the immense fatigue that you're experiencing every day. They're problematic. Your lawyer is going to know how to address those and how best to combat them, but it's also best to understand that they can and will occur, especially in cases where the benefit amount is significant.
So again, good reason to seek help from experienced legal representation as early in the process as
that's true too, and just be mindful of of how you're living your life, and how that is in accordance with with what you're telling the medical and vocational professionals in your life, and just be sensitive to those types of issues. That you do not want to get. The worst thing that can happen in cases like this is for your credibility to be impugned, and so you just don't have anything if you don't have that. So private investigators and snoops, we see those films all the time. You can combat them. There are things that you can do to counter that type of evidence, but it is important it's very important that you counter it, and it's very important just to be aware that it can happen. So.
Great. Well, that's a rather dour note to end things on.
Sorry to be talking about the pessimism in these cases, but the carriers in these cases, especially the insurance cases, the carriers are this is about the money for them. It's not about whether you're disabled. It's not about getting at the truth of your disability. It's about the money, and it's about not paying the money. And they are going to look for any way they can not to pay the money. That's just the nature of this beast. These are private companies that are, by and large, profit-driven companies, and they are reporting to stockholders and shareholders and policyholders on a quarterly basis, and this is what they do.
Set up to be an adversarial system once you stop paying your monthly premiums. So, Mac, thank you so much for spending even more time than you had initially committed helping us understand these complicated issues, particularly since this is something most people only deal with once in their life. It's hard to build kind of a broad expertise until you've gone through it. So we appreciate your guidance, and perhaps you could come back and do a advanced level for people who could watch this one and then get some more specific guidance on some of these topics in the future.
Well, I'd be happy to do that, and you're quite welcome. It was my pleasure, Kim, to be with you and the audience today.
Great. Well, our webinar series continues on Wednesday, September 1st. We'll have another leading expert, Peter Rowe from Johns Hopkins University, who helped establish one of the topics that Mac actually included in the list of things that can be helpful in terms of documenting disability. The problems that many people with CFS experience with orthostatic intolerance and maintaining upright posture, which is usually required for most types of work. So Peter Rowe will be with us to explain orthostatic intolerance and give you some guidance on how to manage that symptom and set of symptoms. And then on September 16th, we have Dr. Tony Komaroff from Harvard Medical School, who will kind of review all the evidence for CFS and the viral connection. And he will include in that XMRV, but it won't be limited to XMRV. So for those who continue to maintain an interest in things like Epstein-Barr virus and H3V6 and other agents that have been associated with CFS over the years, you won't want to miss that program. And I'm just going to flash up a few resources, and we'll include these in the follow-up email as well as some things that have come up in today's Q&A, and I've sent out a couple things through the chat bubble on the webinar system, but we will make sort of an exhaustive list of things that might help you if you are in the process of trying to secure benefits under one of these three types of programs. And again, my thanks to Mac for your time and expertise this afternoon, and to all of the attendees for hanging with us long past the appointed end time. So with this, we'll sign off and be in touch via email with the follow-up for where to find the recording and the slides once those are posted up on our website. So thanks again for another great program, and have a good rest of the day. Thanks so much.